Hello, everybody. Welcome to ProLaLa at Splash 2024. I'm James Grimmelman. I'm one of the PC chairs, along with Srutarsi Basu and Emma Tosh, who are joining us remotely today. I'm really pleased to welcome everybody here in person and online. I'd like to give thanks also to Vasu, our student volunteer, and Sean, who is working AV. And we are going to kick off our program now with a conversation with Matthew Buttrick. There's Matthew. So, Matthew is debugging the
Thank you.
microphone.
All right, go ahead.
Yeah, Matthew is a lawyer, a programming language coder, and a typographer, among many other things. And so we thought he'd be a great example of somebody who is bridging the law and PL communities. So let's just get into it.
In unhealthy ways. So maybe this is a cautionary tale, but thank you for having me, James. Thank you, esteemed guests online and elsewhere. Pleasure to be here.
So you have had a career that spans both law and technology. Can you talk a little bit about how you ended up in this weird space connecting the two that have brought people to this room?
I ended up in this weird space probably the same way a lot of you ended up, which is that I'm a weird person, and I just can't help pursuing every silly idea that pops into my head. So my interest in both design and the visual arts is ancient with me, as is my interest in technology and programming. So I think very much that my preoccupations here in my middle age are exactly the same as they were when I was 11 and 12 years old. So there you go. I just can't help myself. So over time, though, I've just tried to find more ways of blending the two. There you have it. So we'll see where that goes.
So you said you had this fascination with visual design. How did that bring you into programming languages?
Well, my main interest in visual design has always been type design and typography, which if you're thinking of pursuing this as a career, don't. The one big problem is that the complexity of doing type design, the observable complexity, is much less than the actual complexity. People see a font on the page and they say, what, it's just letters, how hard could it be? But in fact, it is very hard to do everything in a font. So as I got more, my first actual job out of college, if you can believe it, was doing type design professionally. And within a year or so, it was, even though I'd kind of dabbled in programming, it suddenly became clear that to actually get to the next level of certain types of work I wanted to do as a type designer, I needed to do software assistance. Actually, here's a fun fact for all of you. Anybody know about this programming language Python? Have you used it? Do you know who invented it, right? Mr. Guido van Rossum, right? Well, Guido van Rossum's brother is named Joost van Rossum, and Joost van Rossum is a type designer. So Python, in part, I won't say was invented to do type design, but Joost and his partner Eric van Blokland were using Python to automate type design way back in like 93, 94. That's when I first heard about Python. That's how I heard about it. I saw them and they were showing me this new programming language, and I said, what's it called? And he said, Python. My brother invented it. So so there's been a very long history of software automation in typography. And in fact, this goes back far beyond me. You can look at the early computing systems that were developed. One of the first things that people made on every system that's ever existed is a typesetting package. Even the gentleman who invented the C language, right, Mr. Kernahan, is that his name? Was the author of the TROF software, right? He's a typography fan too. So there's so many wonderful software. Obviously we're all familiar with TeX and LaTeX, but there's many document automation packages that have been invented over time. So it's just this kind of ongoing subject of nerdy fascination. Anyways, long story is, it is, if you get into type design, there's plenty of software work to be done if you like to.
And so then once you were into programming languages as a way to support the type design, yes, you wound up doing a lot of work with Racket. How did that come about?
Well, the Racket, my work with Racket kind of originates, I have this online website called Practical Typography, right, which is a, typography helping website. So when I first started doing that, though, I said, the only way I want to do this is if I can make it the most typographically groovy site on the entire internet. And I realized that to do that, I couldn't just sort of sit there cobbling together HTML by hand or even doing it with JavaScript. I needed to basically invent my own system for doing it. So what led me to Racket was, as I started to investigate more about how to programmatically manipulate HTML as a data structure, I kind of learned about this kinship between S expressions and things like XML, right? This idea of tags and attributes, they all kind of fit together. So that's kind of what led me to the door of Racket. The folks who made Racket have a really neat document language called Scribble, which is basically the text-based version of Racket. So I said, wow, they already kind of figured out how to do all this document manipulation. So I sort of took that Scribble tool and started to build on top of it to make what is now an open source web publishing tool called Pollen, which I've maintained for 10 years now. But this Pollen system is at the core of every single thing I do online. So even though it took a long time, it really has paid dividends, because I honestly feel I can do things with web pages that other people simply can't, but unless they also use Pollen. So that's kind of what got me into the Racket world, was this desire to see something. And I mean, I think this is an interesting thing because, all these folks talking about, programming languages and especially domain-specific languages. I went the opposite way. I wasn't interested in domain-specific languages and then thought about where could I use this. I really had this problem in my head that I was struggling with how to solve it. And I suddenly realized, what I should do is make a domain-specific programming language. So again, these kinds of commitments, then you spend 2 or 3 years in your home office buried in reading, but it's worked so far.
I mean, comparing that with the story of how Knuth invented tech makes me wonder if everybody with a different programming language paradigm ultimately converges on a typesetting language that is optimized to that paradigm.
That may be so. Didn't Knuth have to take 10 years off to do that system? So I feel like what's that book, The Metamorphosis, right? You wake up in the morning and you find yourself someone who's preoccupied with domain-specific languages, and then years pass. So we'll see if I ever fully get back to it. So.
So the other part of your story is you're now a lawyer. So how did you go from being a type designer who's making his own programming language to do it to being a lawyer? When did you go to law school? Yeah,
I mean, I can only attribute more of my weird curiosity and my refusal to just keep taking no for an answer. As I mentioned a second ago, when I graduated from college, I went right into type design, and I ended up migrating into the web world, of the 90s in San Francisco and so on. And at a certain point, ended up with what at age 28 seemed like a cool little pile of cash. And I said, well, if I ever wanted to do something else intellectual, this is probably the time to do it. And I considered going back to school to get a grad degree in computer science. I also considered accounting for some reason, but then I ended up thinking that law was probably the most interesting and flexible. So I did that. But of course, after law school, I didn't end up. I practiced for a couple years, but it wasn't before too long until people started, being interested in typography. I published a website called Typography for Lawyers, which, again, I didn't expect it to go anywhere, but it turned out that there were a lot of nerdy lawyers across the country who were also interested in it. So, I wish I could say that there was some master plan, but mostly I keep doing these nerdy, weird things. And most of the time they fail, but sometimes they catch on, and at that point I just kind of follow along behind and see what happens.
That's what I tell my students when I recommend Typography for Lawyers to them, is that this is a really good book on typography that also happens to answer the questions that lawyers in particular have, like how do you type the section symbol? And how do you put that into your documents so that it comes out the right way?
I want to point out another thing about typography nobody notices, but hopefully you all will. There was very much a kind of software mentality in the book of trying to, because I've certainly seen plenty of typography books that I feel, I won't say fail, but they make the reader struggle, and that they kind of throw you immediately into the deep end and talking about the golden ratio and things. And I'm like, that doesn't really help. So I really tried to say, like, imagine if this were a math textbook or something, or a programming one. You want to work from simpler concepts up to more complicated ones. So finding a way to sort of sort the information in a way that somebody who was completely new to this material, right, would start to be able to do things and say, I see the value, I see how to do this. That was really important too. That was really important too in that, the beautiful Racket website I have, which is about how to develop domain-specific languages. I mean, just kind of trying to figure out how to, I'm sure all of you have to do this because many of you do classes for students. Kind of putting things on this nice smooth ramp. It's an interesting challenge in itself.
So let's get into some of the ways that law and CS, and especially programming languages, are like each other and are different. So how different is the headspace you get into when you're working on a legal project versus a technical one?
That's an interesting question. I would say certainly that my technological know-how surfaces in my legal work. Of course, I try to automate as much of my legal work as possible. Other lawyers still remain unconvinced this is a good way to do things, but it's headspace. Do you mean elaborate a little bit?
Okay, so I've definitely written code and written prose for other people to read that's supposed to be legal and precise. And there's somewhat different mental places I have to go to in order to do these two things. Certainly the design work for a technical project requires a kind of concentration, but a lot of the line level work I can do in a way that academic writing would be hard. I can do it with less of my brain turned on or a different part of it. So when I'm too agitated to do one thing, I can do the other.
Yeah, I see what you mean. I mean, programming for me is satisfying in a way that is sort of seductive yet also dangerous in that, right? I mean, everything in programming eventually arises from the capabilities and also limitations of the underlying machine. And, so to kind of, so the satisfying part of that is if you're, once you get into the groove of how the machine thinks, you can really get a lot done. What is impairing about it, however, is that that's not really how most things in the world work. And when you're writing a legal brief or something, right, you're having to convince another human being, right, which is sort of a more tangled and messy project in any sense. So sometimes I wonder if that's how we could bring more of that into programming. I mean, programming, I think sometimes when we are using programming languages, it seduces us into forgetting how much isn't there. I mean, when we were talking about this event a few months ago, I said one of the great comedies of programming languages is how bad they are just representing numbers, right? Most programming languages can't represent rational numbers. Racket can. Most programming languages do violence to floating point numbers. Most don't have any sense of infinite numbers behind plus I and f dot 0. So there's so much that is not being represented. So I would say that law's orientation around actual facts in the world is very different, right? And but I think also worth understanding how to grapple with. Programming languages, right? It's always about abstracting away. I always like that phrase, leaky abstraction, right? It's funny because every abstraction is leaky. That's why they call it an abstraction, right? There's stuff that you're excluding, that you're not representing. So to the extent that stuff's being cut out, you're losing information. But at the same time, even though when I engaged with legal writing, there's still a process of you do have to surface what's important, but again, you have to ground it in the actual facts.
So getting into that, how does programming languages represent concepts? And how is that different from how legal language or lawyers represent concepts? Because there are ways in which lawyers and programmers are very much both people who work with words to do stuff. But there's a sense in which a concept or a variable or an assignment in a programming language is very different from what it does from when a lawyer talks about consideration or the reasonable person.
Yeah, and I want to be careful here because this is part of your topic for the whole day, right? And I don't want to say something that's going to impair anybody's enjoyment of your conference. I mean, this idea of, I mean, yeah, you're right. Like, we read certain laws, and if you have a programming frame of mind, you can say, wait a minute, this is something that would have been better expressed in software. At the same time, like, not everything is like that. I think it is, as we think about comparing programming and law, I think it's good to list all the things that you think are bugs and features, and then just kind of invert what you think about it. Because, for instance, I think maybe somebody who loves to do programming and PL theory would think that the way things are described in the law is messy and imprecise. And at times it is. But there are also reasons for that, right? And, whatever, if you want to call them social reasons, political reasons, reasons that allow the law to defer as many questions as long as possible. So maybe these are, maybe there's something to be learned there.
A friend of mine has a joke about a computer scientist who's thinking about going to law school. So his friend is in law school, let's sit in on a class. So he goes to a class, and the professor is explaining a case, and he spends 90 minutes walking through every line of this and just bringing out how precise and perfect the reasoning is, and really illustrating how one thing follows from the next. And the programmer's like, this is perfect. I love this. Like, this is exactly the same kind of logical reasoning that I like. And he comes back the next day to sit on the next class, just make sure of it. The professor has them read the same case, and he spends the 90 minutes tearing it apart, showing how every line contains a fallacy, and that the entire thing is badly reasoned and will lead to terrible results. And goes up to Professor afterwards and asks, wait a minute, which is it? I just wanted to see both sides. And that there's something in that about the way in which lawyers can be comfortable with ambiguity and with there are reasons for and reasons against, and we don't always reach a definite conclusion.
Yeah, I think there's something to that. Another thing that I think about is, whether part of our social agreement to be bound by the rule of law is in part premised on the fact that the law is written in our language, and that anybody in principle can step up and try to make sense of it. And maybe if we required all of the laws to be written in OCaml or whatever, that wouldn't be the case. That would feel more exclusionary. Though we could make another, we could talk about, your average math proof. I mean, there's an argument like, why are you writing it in, English and symbols? You should write everything in like strict formal logic. That's the only, but we don't do that either, right? Because there's this trade-off between wanting to make the reasoning accessible and observable. So I think that is part of what the law accomplishes. Again, lots of mistakes happen in the law, whether they're intentional or unintentional or just failures to reason through things in advance. Yes, I agree with you.
So what do you think would go wrong if we tried to take the entire United States code and just transform it into one large declarative program?
Is that your secret project here at ProLaLa? You're going to propose the...
No, actually. I kind of think that's a crazy idea. There are parts of it that might work for, but I have my own thoughts on why it would fail. I want to hear whether you think this would be a good idea.
Why you think, if we just turned, the entire U.S. code into a software program?
Yeah.
Oh, I think it would fall apart very quickly because, you all may feel differently, but at this point in my programming career, I feel that data representation is the thing. It's where everything starts. It's not algorithms. It's not program flow. It's like you have to have your data structures correct before anything else happens. So, in law, you are confronted with that question right off the bat. How do we represent these things? And I think it's very hard to do that in the language for the reason I said before. Right, every abstraction is leaky. So judges and juries struggle with the definitions of terms. They're leaky abstractions even in the English language. That problem is only going to become harder if you represent it in programming. Unless you also invent like an entirely new way of programming, which maybe should be the first step.
I mean, so one possibility here is that law is messy because the world is messy, and we have to use existing concepts, and then they don't always map onto things in the world. So when you talk about the right to bear arms in the 1800s, what weapons have changed dramatically. in the 107 years since that. If we make a statement about species or about different kinds of animals, then you get the California Supreme Court ruling that for purposes of this regulation, bees are fish. And it sounds absurd on the face of it, but every step of the reasoning to get there has some logic behind it, because this species is like that species for purposes of habitat protection. And like, we're trying to deal with a world in which animals and firearms and other things don't come neatly pre-sliced into existing taxonomies. So part of it's just trying to map our concepts onto the world.
Right, it's difficult, and another aspect of it is that embedded in the law are a set of kind of these threads of, what would we call them, like historiographic or policy decisions. Like, we could talk about how the federal income tax code maybe should just be one giant program, and the IRS forms, which I consider like some of the most beautiful graphic design in the world, in the way that they explain the law in a visual and graphic manner. You know, maybe that should actually be the replacement. But, you know, as my federal income tax professor would have said, he's like, there's so much more happening in the tax code. It represents like basically what was important to our country at every point in terms of what kinds of behaviors they were trying to incentivize. My wife is a appellate lawyer who works for the California government, and she does a lot of legislative history research, right? Which is like something you don't have in code, right? To understand the code, I guess sometimes we do go to the Git history and say, what were they thinking? But in California law, it's a very important part of interpreting laws, is to go back and say, what did the elected representatives think at the time that they were drafting it? And maybe they didn't get it completely right, but we can at least go back and try to reanimate in a better way what they were going after.
So we've been talking a bit about parts of law that don't naturally map onto things computer scientists do. What do you think is the hardest part about computer science for lawyers to appreciate? Like, what do programmers understand in their bones that lawyers don't necessarily appreciate?
What programmers understand in their bones is that like laziness is such a good urge, right? And it motivates you. I think what the most amazing thing about, now that I'm, I didn't practice as a lawyer. Like I mentioned before, I got out of law school, practiced for a couple years, and then stopped for a long time, and got reactivated a couple years ago to get involved in some of these litigation. So it's funny to me because I'm suddenly working on these cases that have dozens and dozens of lawyers, and these are very busy, well-trained people, but the amount of, I don't think I'm giving away any state secrets, the amount of actual automation, right, that is part of the average lawyer's workday is very small. Right? So, and as a programmer, I just think like, oh my gosh, we could write this, all these discovery requests or responses in a racket program that's 20 lines long. And in fact, I do write small programs to generate some of my more complicated documents. But I would say that's a big one. I know it seems kind of prosaic, but it's more than just an operations or productivity thing. Again, it's a way of thinking about how you do your work. To get back to that earlier anecdote I said about inventing practical typography and the pollen system, right? The shift in my thinking was going from thinking of HTML as a place to do work, right, as a language unto itself, which it is, but it's a terrible language to use. Thinking of it more as the output of a better, smarter system. So as a lawyer, I think about this too. Like any document I make, I'm like, wait a minute, I'm making this document. I should think of this as the output of a better, more generalized system. But it's surprisingly sparse. I think I've heard every now and then over the last 15 years, I get an email from a lawyer who said, I'm starting a new practice and I don't want to use Microsoft Word. I want to use LaTeX. And I say, let me know how that works out. I mean, it's going to be good for you, but the day that you have to send something to another lawyer or a judge's chambers, you're going to have a copy of Microsoft Word.
So we're going to hear more about this later today in Charles Duan's tutorial, but I do actually write the majority of my articles now in LaTeX using Charles's Blue Book citation package. And it's exactly right. The pain point comes when we have to leave that self-contained world and provide Word files for the law reviews to edit. And the export or rather the import capabilities of Word have gotten good enough that if I produce a PDF from LaTeX and then import it using Word, it comes out approximately right. There's just a lot of small formatting changes that have to happen. But the thing is, the law review editing process is so inefficient and so much a process of transitioning some Word file into the journal's specific Word format that most of the time that extra work just gets eaten up in the work the journal would have done anyway.
There you go. I mean, I think it's, I actually have, here, I'll out-nerd you a little more. I can't bear to use LaTeX, but I thought, you know what I'll do? I'll make a better version of LaTeX for my own use. So I have a document processor called Quad that I wrote in Racket, and it takes my markup files, and it lays them out, and it compiles them into PDF. Boom, all in one place. It works beautifully. I don't know what to do with it, and I don't know who to share it with, because this whole mode of working, right? The attorneys that I work with now, it's like they don't. I actually sometimes wonder if I'm just a little bit before my time, and I'm interested in your view because you have younger students. I kind of wonder if it's generational that I'm like Gen X, right? So people of my age, they learn to about document preparation. In my case, on a typewriter, or at worst on like a personal computer, right? But I don't know, maybe are younger people thinking more in terms of markdown, right? In terms of like, hey, I'm doing something in a markup language that doesn't necessarily literally correspond, right? This whole WYSIWYG thing, that's very much an 80s artifact. And I sometimes wonder if maybe if I just wait 10 or 15 years, once these young people become experienced lawyers, they're going to be like, give me a better document processor. What do you think?
I think that young people in computer science absolutely think this way, and absolutely use a variety of markup languages or structured file formats. So TOML or YAML or something using a JSON or anything that has some structure. And they're very comfortable weaving among multiple files and formats. And I mean, maybe the problem is that there's, as with any standard, there are so many to choose from, but it's absolutely part of the intellectual toolkit. This has not penetrated at all to law students.
Well, what can we do to fix that?
Send more technically savvy people to law school.
Why do you think that resistance is, though? I mean, it just seems like lawyers would love this. I mean, you as a legal academic, are using these tools in your own work. Obviously, you're a little, special in that regard, as far as being technically adept. But why aren't people lazy enough and to want to learn these tools?
So I think that they're really like two broad tribes of lawyers, which are the people who really like the logical part of it and the people who really like the arguing part of it. So there are some people who really love the abstractions of law and understanding how things fit together. Some of these people are really happy as tax lawyers. Some of them work on deals. And then there are people who really love words. And they may have been happiest in their history or political science or English classes and are glad they never need to take math or programming again. And they see things in terms of words and their meanings and how to string them together. And the idea of a program to abstract it is somehow cutting them off from the thing that they really like about law. And it's like, I didn't go to law school to do this.
Yeah, that's a good point, and I think it also loops back to your question about distinctions between programming and the law. Once we, in programming, once we decide on a data structure, I mean, I mentioned before it's an abstraction. Things are left out that maybe should be better left in. But there's also an implication there. There's an assertion that this is somehow the ground truth, and that's just not how it works in law. Like when people say, "Oh, facts are objective," no, they're not. They're not objective. I mean, that's why we have juries, is that facts are often in dispute, and somebody has to decide what the facts really are, and it's a matter of presenting evidence. We never have to do that when we're writing a program, right? We never have to sit in front of OCaml or Racket and bring evidence to convince the programming language to give us the data structure we want. Maybe we'd be better off if we did. But it's an interesting kind of, there's more, I don't know, maybe there's something to be said for putting that kind of freight on the person who wants to assert a certain view of the truth.
I mean, I teach intellectual property, and when I get to copyright and infringement, and I have to start showing my students examples of what's similar enough to infringe and what isn't, they invariably ask me, okay, what's the test? and I recite back to them, well, it's substantial similarity, whether the defendant has copied a material amount of protected expression. Like, what does that mean? Well, here are some examples. Let me show you. Is there a rule? Like, you learn it only by seeing what judges and juries have decided is too similar and sufficiently dissimilar that it's okay.
Yes, exactly. So yeah, it is a lot more wobbly. And in fact, I use this. I use this example in my typography book because I talk to lawyers sometimes think that all this typography stuff is just about looking pretty, and they don't quite believe that there's something substantive about it. But I make this point, like, just imagine a jury trial, right? When you're presenting evidence, part of how you, and in fact, juries are instructed, right, when a witness is on the stand, that you can judge the credibility of their testimony, right? You can judge the facts coming out of their mouth that they're testifying to based on their demeanor or how they present themselves, right? I mean, juries are specifically instructed to use presentation, right, as a means of weighting their substantive understanding. So I feel like a corresponding thing happens on the written page.
I'm at the point where I cannot even work in formats that don't have some structure and produce decent-looking outputs. There are plenty of people I collaborate with who are totally comfortable just having a Google Doc that has 40, 50 pages of notes from our meetings and random thoughts and fragments scattered, and they can jump back and forth. And like, I certainly have lots of unstructured text and clippings saved on my computer, but the actual document I'm working on, it always needs to be in a state where it compiles to something that looks good.
Yeah, that's a good tip. I mean, the sort of underlayer of all my typography discourse is also that there is a kind of stealth programming component, right? I mean, honestly, there are a lot of people in the world, not just lawyers, who don't know that, like, what a hard page break character is and what it does. It's like, that's a form of like control of your document, of programming your document. That's just so basic, right? If you're a programmer, but it's new to a lot of people who came from a different direction. So learning that they can control their document that reach that first level. I don't know. So I sometimes wonder, right? It's like, if I show people that there's ways that they can control their document that will save them time for the rest of their life, should that make them more interested in these tools? I don't know. I'm not sure I'm making much headway, but I make the argument anyhow.
Are there places where you think that are really promising for overlap between lawyers and programmers? Places where they think the same way, that we could really tap into that synergy?
Oh my gosh. Synergy between what are you hoping for?
I mean, you've talked already about the idea of convincing lawyers to automate, that programming and tools that let you move up a level of abstraction could actually let you cut out a lot of the busy work and do the things that are interesting and important. So that's one of them, is the legal tool chain that lawyers use to produce their work product. Are there other places where there's some kind of connection that one could really learn from the other?
Yeah, I think of it more, frankly, like, I think programming could learn more from the law. I kind of wish, after decades and decades of programming, that there were more different kinds of programming, in the sense of, I don't know, messier forms, probabilistic forms. I mean, I guess, some of you know about my work with these, AI cases, but I actually think AI is interesting technology in that it does represent a different way of modeling information and producing a result. I won't call it an answer, because that implies it has a truth value. But again, to kind of go back to something I was saying at the top, pretty much our entire culture of programming, 60 years into whatever kind of modern computer programming, is all based around machine architecture, and it is very strictly focused on that. I think it's actually no coincidence that, to me, I perceive in the last few years, there's kind of a growing interest in what I think of as low-level languages like Rust or Zig, or even Swift to some degree, right? Compiled languages, typed language, things that really go hard and close to the metal. People are kind of rediscovering this, which I think is great, right? But at the same time, I also sort of wonder, I don't know, what's out there. Have you ever used a quantum computer, by the way?
I have never used one, but I wrote my undergraduate thesis on quantum computation.
Okay, so you like that just represents a different way of doing computation, right?
Yeah, and the idea of the thesis was, hey, like, we don't have any of these devices yet, but when we do, the rest of computer science is ready to make use of them. And
yeah. Oh, I'm sorry. Go ahead.
yeah, it's kind of unfortunate that we really have not figured out any more uses for them in the 2 decades since then. It was factoring numbers more effectively and speeding up database search a little bit. And those are still the only 2 algorithms of interest in the entire field.
And you also need a quantum computer to do it. Like I've not done any programming on the machine learning side, but I have done a little bit of sort of good old fashioned AI programming with Racket. I did a whole package for doing constraint solving problems. You know about those, right?
Yeah.
A little bit. But I mean, I just think that's just a really interesting way to tackle a problem, is to program a solution by not really programming it, right? What you're doing is you're describing kind of the problem space, and you're letting the computer search that solution space in different ways. And it's fun because, it's like math is real, probability is real, and, you can, hill climbing algorithms work if you drop enough random searchers around the search space. It's just really neat how it actually doesn't fail every time. So, but again, these kinds of techniques, I was working on that because I wanted to, if you can believe it, I was trying to figure out a way to lay out footnotes in Quad, and I thought, this is what I need, a constraint solver. And unfortunately, it does work for that purpose. So I'm not sure what the lesson here is. I just keep learning that these things do work, but it kind of takes me farther into the rabbit hole. And lest you ask, yes, I am aware that the optimal paragraph line breaking algorithm in LaTeX, I know all about it. I did implement it in Quad, so I've got that too. Don't worry. Also, the hyphenation algorithm in LaTeX is very beautiful and interesting. I've implemented that one too.
And yet, the page breaking and page arrangement in LaTeX is so bad.
I think famously, that's not an optimized algorithm, right?
Yeah. Anyways, going back to something you mentioned briefly, you have reactivated your law license and gotten back into that game because of the AI litigation. So you've been counsel on lawsuits against generative AI companies for training on authors, artists, and programmers' work without their permission. As a lawyer and programmer, how are you thinking about generative AI and about human and computer creativity?
Well, that's kind of where it all starts. I mean, some people like these cases, some people don't, and I welcome all the views. I mean, I've heard from everybody, and I understand it's a controversial topic. I mean, for me though, it began very personally a couple years ago when this GitHub Copilot product was released. And it was just very easy for me to see. I mean, what's my business really, right? My business is I'm just a dude on the internet. I've been self-employed for 30 odd years, right? I'm a guy on the internet. I make things. A lot of them I don't do for money. Some of them I do. Sometimes people pay. Like, that's it. Like, that's my world. And as soon as these systems started to surface, it was just so easy for me to see that within 3 to 5 years, people like me are gone, because it's just going to be so easy to create a fake person who's more interested in having, an X and a Threads account than I am. And, do you know what I mean? It's like, it's just going to replace folks like me. And it also became clear to me that my own personal work was in the data sets of all of these systems. And with the Copilot one in particular, right, that was a special case because I've been involved with the open source software world for 25 years now. And, it's easy to see that by creating this new way of accessing open source software, which is to say through a language model rather than through, let's call it like a community-based, interface like GitHub or GitLab or what have you, that, people's entire perception of open source was going to change. If any of you are involved with open source software for any length of time, you know that the economic problem of how to support open source software has never been solved. And it's really kind of crazy that that's the case, right? Because 25 years on, 30 years on, open source software is more critical to global software infrastructure than ever, and yet it seems to be getting harder than ever to find funding for it. And for me, like this moving it into language models is just going to sort of threatens to collapse, that last, part of its vitality. So, yeah, I mean, for me, this is like an existential threat to what I do on the internet, and I think that the extension of this, again, that I could foresee, is that like I just don't do this anymore. I'm not going to be able to do programming and typography and write, because it's just going to be obliterated by AI slop. And I'm not saying now, and I was right, but I think in the last 2 years, folks who are not me have started to see that, yeah, I mean, this rising tide of AI stuff that's sloshing around the internet kind of presents some maybe unforeseen consequences to folks. I mean, how has it been in academia? Like, how are you dealing with, the generated papers, that are AI assisted, right? Has it been a problem as far as reviewing or reading things?
So I haven't personally come across AI generated papers in my line of work, but you can definitely see that they're starting to really infiltrate the lower end of academic publishing. So there are a lot of journals that are basically existing to help people get publication credits for universities that don't care what you do as long as you have publications. And those are getting hit with AI-generated submissions, some of them comically terrible. And it's one of these things where it's a disruptive innovation in the classic sense. It's going to start at the low end and just eat its way up. And I won't be shocked if there are people who are using these tools as part of their workflow. You see companies that are promising to help you find the citations for your work, and there are tools that will obviously polish your writing. So I suspect that many of my colleagues are already thinking about how to do this, and that might not be so destructive. It's the slop that I'm really worried about, because the AI slop is going to overwhelm all kinds of filters. Not the one person who crafts a paper with AI support, but the person who pumps out 100 papers that are garbage, but that take effort and time to filter out from whatever screening you're using.
Yeah, that's a great point. And this is consistently my experience with generative AI, whether it's code or art or writing, is that the time it takes me to correct the output, right? I feel like I'm just correcting a 12-year-old's homework over and over, and at a certain point, I would just rather do the homework myself. Thing one. And thing two, you raise an interesting point where there's folks who are in positions of, like, they have education, they have experience, and they're like, well, if I just use this a little bit, what's the harm? And if you're standing athwart AI, you're like a gatekeeper. One of the most heartbreaking things I've seen in the last year, AI related, I wrote a little bit on my blog about Chief Justice John Roberts wrote a report last year, right, about the judiciary, his annual report, and he talked a lot about AI. And one of the things he said is that he felt that AI could possibly be a way of expanding access to justice for people, indigent people. And I was just like losing my mind. I mean, the entire premise of our constitutional system of rights and the judicial system is that we protect the most vulnerable. And the idea that we're going to take the most vulnerable and give them the absolute shittiest possible tool to defend themselves is boggling. There was a video circulating, 6 or 8 months ago of a Ninth Circuit argument where the lawyer had plainly relied on ChatGPT or something like it to write her brief, and the panel was just not having it. They were saying, but this case doesn't exist, and this case, and this case, and it just was heartbreaking. But the thing is, the case itself was even more heartbreaking, because this lawyer was here. It was a case, as I recall, about kids who had been forcibly removed from their parents by the police. It's like, this is an important case, right? Like, that is exactly the kind of case we want to be litigated correctly. And yet, like, this is the case where, to Justice Roberts' point, right? It's like, and this is the kind of case that's getting ChatGPT. It boggles me. And it frightens me, because, I think that when you start playing out the trajectory, it's like the wheels start to come off.
There's a very serious set of initial inquiries now from a group of people who are starting to feed legal materials into ChatGPT and say, hey, this looks as good or better than what judges write. So why don't we turn things judging over in part to them? So there's David Hoffman and Jonathan Arbel have written a paper about asking ChatGPT to do contract interpretation. You give it the contract and you ask it a question, and that answers your interpretive question. Adam Unikowski has been feeding Supreme Court briefs into ChatGPT and then asking it to write an opinion that resolves this case. And it really feels like, as one of my collaborators says, vibes-based interpretation. Like, this looks kind of convincing, so isn't that as good as an actual opinion written by a human who thought about it? And it's actually quite terrifying prospect.
Let's say more about that, because when I talk about being scared about this stuff, I feel like I'm the only one, but you use the word terrified. So how do you find it terrifying?
So I find it terrifying because if your test for is this opinion a good judicial opinion is, does it read well? Does it sound convincing when you look at it? That just, in some ways, opens up room for judges to have ChatGPT write whatever opinion they want. They can say, I want to find for the defendant. Make me an opinion that looks ironclad that does it. And you've severed the link between, like, good faith judging and the output. They're trying to present the output as the inevitable result of well-supported legal reasoning. And if it's just whatever ChatGPT spit out, then it's not the inevitable result of valid legal reasoning.
Well, I think that's a great point. And I mean, I feel the same way about, I mean, I've talked about how, you know, I see AI as being the ultimate, like, laundering device for human behavior, right? Because, and I mean, and you kind of alluded to that in your great paper about the literate robots, right? I mean, how once machine reading has special privileges, that we create incentives to sort of funnel our reading through it. Am I mischaracterizing? I feel like
no, I think that's right. To summarize the idea, this was back in the days of Google Book Search and some other cases like that. The courts held that these kinds of ingestion of copyrighted works were fair use because Google was just using this to provide a search index. It told you what was in the books rather than sharing full books with readers. And this kind of automated mass consumption of books was basically not expressive. It wasn't the kind of thing copyright cared about. And a lot of the AI companies relied on precedents like that to argue that the mass ingestion that they've been doing has also fair use. The principle would be that bulk technological uses of works to recombine them in new ways are inherently fair. And I think that equation breaks down to the extent that generative AI actually emits new things, that it produces new works that are also expressive, that could compete with the works it was trained on. I mean, you have to go back to square one and ask, is this fair use under the traditional factors we consider?
Yes, I think that's a wonderful argument. I'm going to actually nitpick a little bit with you because you just said that the output of a language model is expressive. I don't think it is, and I think there's law saying that it's not. Did any of you follow this case, Thaler versus Perlmutter?
Yes. This crackpot inventor submits a piece of art to the Copyright Office that he says was generated autonomously by his AI with no help at all from him. He wants a copyright. The Copyright Office says, no, it was produced by a machine. That's not copyrightable. He sues, and so far he's been losing.
Well, yes, but it escalated to a district court case, and the judge in the district court said, sorry, sir, your work, you know, it's not copyrightable. But to say a work that comes out of a language model is not copyrightable is also to say there is no protectable expression in it, right? The output of a language model, as of right now, has the same legal status as a stream of random numbers. It is not expression. It is not protectable. The court said so. So I think, you know, it's kind of an interesting wrinkle on, or twist on the fair use argument that, yeah, a lot of fair use is about facilitating downstream expression, but that's not what language models produce. That was a sidetrack. I wanted to get back to, though, agreeing with you. I mean, I think you made that great point in Literate Robots that, yes, as these systems now become exactly kind of merge into the lane, or seem to, right, of what humans do with writing, these analyses become trickier. And I think that the effect that James describes, you know, of how these systems affect reading and writing are going to be writ large across the economy any time that an AI system is injected, right? people are going to allow the AI system to do the things that they themselves, can't do or won't do, and that is also terrifying. Because even today, right? I was reading a story about 6 months ago of a health insurer that was basically using AI to determine how long people could stay in the hospital, right? This sounds like, oh, they're just trying to cut costs. No, they're trying to kill their most vulnerable patients, right? They're trying to get them out of the hotel, the hospital, so they'll go die at home, and then they won't be a burden anymore. And then they can say, oh, well, but the AI made the decision, right? And this is going through healthcare more broadly. I mean, if you know any doctors, ask them. They will tell you that AI is infecting how certain procedures are approved by insurance. So this is going to be a widespread problem.
So I'll do one last question, and then we'll take any questions from the audience. Would that be different using an AI machine learning based model from a traditional hand-coded, constraint-based rule AI? Would that make a difference to how you think about it?
You mean, I'm sorry, like the two different kinds of AI?
Yeah. So in one case, the AI is learned from examples, and it's run a machine learning algorithm that nobody understands quite how it translates into the outputs. And in the other case, some programmer sat down and used a declarative language to write a whole table of what the output should be under various combinations and conditions of inputs.
Well, that's a wonderful question, and I think it's a question that occupies some of the biggest brains in AI right now, and has for many years. This kind of this question of how do we advance AI, right? How do we get to AGI or whatever it is you think is the end point? Is it by scaling up the language model, right, which is just sort of emulating patterns that it finds in its training data, or is it from this, what's called good old-fashioned AI, right, constraint, principle-based, working, kind of working from the bottom up, if you will, versus from the top down. And it's a big debate. I guess so if you ask me, like, as somebody who knows nothing, which camp I'm in, I'm certainly in the people who think that the only way to do it is from the bottom up. Like, I like math. I like, you got to work from first principles. That's the only way out.
Well, you like a different kind of math.
Well, yeah, maybe a different kind. So maybe there's some way to blend the two, but, certainly, what's appealing about these language models and generative AI art things, it's like they make things that are appealing and seductive, but as you say, often not even close to being correct in any way that we as programmers or mathematicians would care about. So, yeah, for now, I like the good old-fashioned AI.
Okay, thank you. Questions from the participants? Yeah.
We'll let him have a microphone.
You can have my microphone.
That's a wild.
And we'll run yours over here.
Okay.
Hey, thank you for this great conversation. So my name is Rohan Padde. I'm a professor at Cornell University, and this is my first time, attending this conference, this workshop, or thinking about law. So I primarily do research in program analysis and like bug finding and finding security vulnerabilities. So going back to your sort of conversation about how lawyers sometimes have to think like programmers. You discussed various aspects of when lawyers are working on, let's say, like legal cases where you already have an existing law. There are obviously the challenges with thinking programmatically. But I'm more interested in the process of creating laws themselves, right? So the legislative creation process, or maybe if when you think like drafting contracts between two sort of business entities. I feel like as a person who's not a lawyer, a lot of the sort of challenges I've seen people deal with when thinking about like corner cases or edge cases where you have things like loopholes or you have inconsistencies, often are similar to the kinds of issues we see in programming, where you have there's a specific intent by the authors to create a set of rules that should behave in a certain way. But then there are these edge cases that are not easy to reason about manually when one is writing them down, but then they end up becoming a problem once you have the system in production and somebody is able to figure out what this edge case is and then exploit it in a way that may not be the way that the original author intended. And then you get things like bees are fish eventually, where it's like a series of changes that are applied to laws that eventually end up being interpreted in ways that maybe the original creators did not want. So I guess there's a long context, but my question is, do you see in that process, in the legislative process, a opportunity for things like programming languages, formal methods, or even some of the recent automation like large language models being useful in reasoning about what could go wrong, or what are the possible ways that this text could be interpreted that we aren't really considering right now as lawyers?
Thank you. I think I understand your question very well, and I think you're not going to like my answer, which is I think it has no utility at all, and not for the reason that you think. I mean, I think as a mathematical and programmatic way, it would be wonderful to be able to sort of check our reasoning of our laws. But here's the question. Is the point of our laws to be correct? And I would submit to you that it's not, right? Like, you use the term loophole in your question, right? A lot of people use loophole with a note of pejoration, right? Where it's like, that's a bug. Loopholes are not bugs. Loopholes are put into laws by people who want the loopholes there so that they can drive a truck through it later, right? We see this all the time, right? I mean, there is a political performative aspect to legislation, right? And the language that is on the page is a compromise between a bunch of different people, some of whom will want a certain outcome and some of whom will want a different one, and certain people who want the outcome to be ambiguous, right? A lot of times it's like, we don't want to know what the answer is. We want to kick it down the road and see what a judge will say, because we think, so I think if you stood up and said to a legislature, like, here, I can completely software automate all of your legislation, would you like that? They say, no, thank you. No, we'd like to keep things a little wiggly and wobbly. What do you think?
So I do actually like some of Sarah Losky's work in this space, where she's tried to identify the kinds of ambiguities in tax laws that there would be no plausible reason for anybody to want. The questions of, does this term scope to a paragraph or to a subparagraph? Or cases in which there's simply an ambiguous referent, and it refers to one of two things, and we just need to figure out which of two things that term refers to. So I think some of the cross-referencing kinds of issues probably are eliminable ambiguities. There are other cases where, like ordinary and reasonable, we're never going to automate ordinary and reasonable as a term or commercially reasonable efforts in a contract. The smart contract dream of getting all ambiguity out is a fantasy. But I think there are some kinds of very clear, almost syntactic errors that it wouldn't hurt to be able to at least lint out of the process.
That may be so, and probably tax law is a great example, but also sort of special, right? As I indicated before, it's, if anything, the part of the law that is most susceptible to, just being considered something of a software program. Though not strictly. Lots of deliberate ambiguities in the tax code as well, for those who are interested.
Tiffany.
Hi, I'm Tiffany Lee. I'm an associate professor at the University of San Francisco School of Law, and I have kind of a small or a big question. Do you think open source licensing actually works with LLMs? Given that we have so much data, and if you want to open source it, are you going to open source every single data set that is used to train an LLM? Is that even practicable? And secondarily, is that in line with the ethos of FOSS? Right? Are we thinking that current AI, owned by these tech companies, is still something that we can ethically consider part of an open source movement?
Well, what's your view? I mean, but finish the thought, please. What's your thought on that? I mean, I know the Open Source Initiative is considering this issue right now, and Meta is resisting. So, I mean, what are you thinking about it?
Yeah, this is something that I've just been trying to figure out for myself. So I would love to hear any of your thoughts, because it seems like, I would love to have open source still be a thing moving forward, right? But then if you're considering, what does that license look like? Are we open sourcing model weights? Are we open sourcing every single data point you use? How can we possibly enforce that? And then I was thinking, the AI companies now, they're extractive, they're exploitative. Is there any point in trying to make them move back towards an open source, respectful model? Is there some way forward, even in this new environment that we're in, this sort of corporatized AI environment? What do we do now?
Well, I can give you my, again, I'm like a big open source fan from long time ago, and it may be that my views are completely obsolete and I should just drop dead. But I think like open source should mean something, right? And I think we do see this problem right now in AI that a lot of people are throwing around the word phrase open source and just kind of deciding it means whatever. I actually, in a funny story, like one of the nerdiest moments I've had working on these cases was about a year ago. I was in a courtroom. Judge Orrick up in Northern District of California, we were at a hearing about these the stable diffusion model. And he said to us, hey, it's an open source model. How is it that you weren't able to go figure out X, Y, and Z about it? And my co-counsel said, Butterick, go up and answer this question. So I had to give a little talk to the judge, who was wonderful and very like technically minded. But I had to say to him, well, Judge, yeah, you're right that the software itself may be open source, but the weights file isn't, right? It's like a Nintendo and a cartridge, right? You need them both to work together. And unless we can see what's in the weights file, it's not really open source. And he's like, all right, I buy that. But it kind of goes back to your question, right? How much of these systems need to be open? And I think actually it is kind of a dumb game that they are open sourcing, you know, whatever, the inference and training even, but not the data. So I think where the OSI is coming out, didn't they just recently say that if you're going to call it open source, you need to open source your data set as well? Isn't that kind of, or at least disclose it? I think that's the right answer, right? I mean, to me, open source software means you can, you know, download it and you can run it yourself, you can build it yourself, and you can modify it. And for a machine learning system, that has to include the training data, right? So if you don't have access to the training data, you've only got a part of a system. And I think in the previous world of open source, if someone said, you know, if Microsoft or Apple or someone like that had said, here's our open source software, it's all open source except for this 80%, we'd say that was pretty shady.
Yeah, I think that there's a crisis in open source right now. It's coming on a lot of fronts. One of them is the economic sustainability point that you mentioned. But another one is that with AI, suddenly the definition of what artifacts you need to make it open source is ambiguous a bit in a way that it didn't used to. Second component is that it's not obvious what things the license attaches to because the copyright in them is complicated or non-existent, depending on how you look at it. And then the third is that the underlying power relations of who is able to do what with what don't cleanly map onto the way that open source worked for decades, where the idea was if you had the source code and you had the legal right to work with it, you were free in a meaningful way to go do it on your own. And when you are looking at data sets and models that take millions of dollars in compute to train, suddenly that's not quite the same freedom that it used to be.
Great, thank you.
Can I add one more thing? You know, that I don't know if any of you remember the Affero GPL, AGPL, and why it came to be, right? You know, but this was a struggle back in, I think, the late 90s. The GPL software was starting to be used on internet servers as sort of the early cloud-based services. And what the GPL folks were realizing is that it kind of amounted to a circumvention because you could deploy GPL on a, you know what I mean? You weren't like sending it to users, you were keeping it on a server, but it was not preserving the sort of open sourceness. So the whole point of the AGPL is if you use the program on a server, you still have to distribute the source code. So I don't know, maybe we're going to reach a place like that. You know, it's weird, right? Because open source licenses kind of traditionally can't discriminate against types of use, right? So, you know, forbidding people from using an open source software for AI training, you know, is its own struggle too. So I'll be interested to see what the OSI comes up. It's a knotty problem. Thank you.
So I think we are going to stop it here so we can go on to the scavenger hunt. So let's thank Matthew Buttrick.
All right. Thanks for having me.
Thank you. So we are going to continue now with our first social and getting to know each other event. Can we put the slide from my computer up on the screen now? So we have a bingo and scavenger hunt event. There is also a link to this. Oh, yes. I'm sorry. Yeah. It's totally my fault. Okay, it's plugged in. Let me check my displays. That should set, it's set to mirror. Okay, is it visible now? Go ahead. There is also a link to the bingo form in the program for the day. If you look under the bingo hunt, scavenger hunt section in the event, you can see the link there to click on to make your bingo board.